We've interviewed many people here on the channel who were cheated by bad franchise companies. Today, we've got an interview with one of the good guys who helps buyers with avoiding making mistakes. James Ullman is a top-rated franchise lawyer. He's been kind enough to speak with Pam Currie here at Franchise City about things you need to know in the franchise agreement that if you do not know can come back and bite you. Things like, is your spouse in some states automatically liable for your business losses, and why you could actually end up being personally liable for hundreds of thousands of dollars even if your franchise closes. Don't end up losing your money or buying a bad franchise. Always call Franchise City Consultants. Here's the interview.
I'm going to kick us off with some pretty sensitive items in the franchise agreement. And the two sensitive items I want to touch upon before we get into explaining what the franchise disclosure document is all about is liquidated damages. And the second one is that personal guarantee. Two sensitive items that often come up.
Okay.
So with that being said, first and foremost, explain liquidated damages. Explain this to us.
Sure. Liquidated damages are a way in which the parties agree up front what will be the responsibility and damages if there's a breach of the contract. Put in the context of a franchise system, let's say we have a 10-year term, and for one reason or another, one or both of the parties decide it's time to part after the second and third year. There's a formula already written into the franchise agreement that will say what the responsibility of the franchisee is to the franchisor for future royalties. These are clauses that are supposed to take away the uncertainty, and because a franchisor that would be a plaintiff in a lawsuit or initiating an arbitration would have the burden of proving exactly, what are the damages. And if you haven't been in a system for a very long period of time, the damages from the franchisor's perspective might be considered speculative and therefore difficult to prove. So that formula basically lays it all out. On the franchisee's side, they know what their responsibility is, and that's a two-edged sword. That can be a good thing, or that can be one in which they should consider negotiating going in to make sure that they understand that if they do leave prematurely, they can't argue that it's speculative anymore. There's a contract with a formula, and they've agreed to it, so they're going to have to pay it. So oftentimes those are negotiable, and I would encourage somebody that has getting into a franchise agreement that has one of these clauses to take a careful look at them and talk to their attorney or advisor, because they typically start out at 3 years of payment of the prior 12 months rolling average of royalties, or 6 months. And that can be a lot of money. And so it's something to be concerned about. Absolutely, like you say.
That makes sense. And is it common, for that to be in the franchise agreement, or do you find some franchisors don't even put that clause in place?
I see it more often than I don't, but it's hard to quantify. If you tied my hands around my back and made me give you a percentage, I'd say I see it about 60% of the time in there.
Okay. All right. That makes sense. So let's go on to that. Anything else you'd like to add around liquidated damages?
Only that I do find that if it's and this is a thread or a concept that I think we'll be talking about in the next hour a lot. If you're dealing with a young franchisor as opposed to a seasoned system, you ought to try to negotiate several things, because you have, more economic sway in the negotiating process, because they're probably very eager to build up their system. So consider trying to get the 3 years, if that's what it is, down to 2 or 1. Perhaps a formula, a flat fee, as opposed to a percentage that you're not exactly sure about because it's based upon royalties that you haven't sent to them yet, based upon sales that haven't been derived. So those are a couple of the tips.
Nope, great tips. Thank you for that. Let's go ahead to that second sensitive item in the franchise agreement, and that's the personal guarantee. Explain that to us.
So essentially, franchisors want to make sure that a married couple, if the wife is the franchisee, that they have the guarantee of the husband and vice versa. And it makes collection so much easier. So that's why generally the signatures of both husband and wife are required, because typically a franchisee will want to, and the franchisor will encourage the franchise to be run with a corporate vehicle or an LLC to protect the franchisee personally from any liability, such as like a slip and fall case, somebody walking into a brick and mortar location. So they're all in sync on that. But since the franchise is going to be owned by an LLC, it's important to make sure that the franchisee's commitments to the franchisors are guaranteed. And it's expected that the franchisee will do that. Where the proverbial rubber meets the road is, what about the spouse that's not involved in the business? And there are the answer to the question, can one signature bind the marital community, is a case-by-case analysis by state. So it's difficult to give any guidance, but I can say this. There are 9 states in America that have community property laws, most of them out west. And it is incumbent upon the franchisor to get both the husband's and wife's signatures in those states. Otherwise, it would be very difficult to enforce a personal guarantee.
Okay. Would you, with the personal guarantee, would a good analogy be like if you're going to get a loan from a bank? Very often they require that personal guarantee. Is that really sort of a similar?
It's an exact analogy. Yeah, right.
Okay. I actually, you brought up something, which is, forming your entity, and, a lot of prospective franchisees, become LLCs, and that's what the franchise agreement is in place with, is with the LLC. Is it, the way I understand it, and please correct me if I'm wrong here, is that they have to mirror one another in regards to whoever's on the LLC. Let's just say it's the husband, and they've chosen not to put the wife or significant other involved in the LLC. That means the franchise agreement itself also just needs to have his signature because he is the only one on the LLC. Is there a mirroring there that is required?
Well, sometimes it depends on what the franchisor wants and what their practice is. They can have the LLC through one of the members of the LLC that they're akin to shareholders, or the managing member of an LLC can sign, and then the personal guarantees of both, or it can be done as individuals signing. And then almost every franchise agreement that I've ever seen or written, allows for a transfer into an LLC as long as the parties are identical or a majority ownership. And that's done routinely. So it can go either way. But the idea is, at the end of the day, that individual signatures are either on a guarantee or on the document themselves.
Okay. Okay, great. Well, we really just dove in right off the bat here with these 2 sensitive items, and I kind of want to back up and just give a general overview of what we're talking about. We've been talking about the franchise disclosure document, fondly known as the FDD, and you and I go back far enough to know that it used to be called the UFOC, which stood for Uniform Franchise Offering Circular, which is, I kind of like that just because I think it gives you a good understanding. It's a uniformed document. And the data is all different, but it is a uniform document. For our listeners, please share, what is the layout of a franchise disclosure document?
Sure. And this hasn't changed all that much since 1979, when the Federal Trade Commission enacted the rule, and various states had franchise regulations and adopted their version of it, the UFOC. And for a while, there were parallel, there was an FTC disclosure document and a UFOC document. But over the last several years, 15, 20 years, it's the FDD and the UFOC previously. They haven't changed all that much. There's certainly been significant changes, but in terms of the layout and the information requested, it's 23 items with multiple subparts, and those don't change at all. And the first 4 are pretty much background, tell us about the franchisor, its affiliated related companies, its predecessors, and then the business experience of the owners and CEOs, salespeople, and the like, the key personnel, and their 5-year work history. And then there's a litigation disclosure. If there have been litigations or arbitrations, they have to be disclosed, and also the results of them. And then any bankruptcies of the same individuals that are referenced earlier. So that's that part, just to give everybody reading the document, who are we dealing in, what's their past? And then we get into the next 3, which are the meat of it in terms of the money. And that's the initial franchise fees, all other kinds of fees payable to the franchisor, and in a chart with a high and low range of investments, including some consideration of working capital for the first 3 months, or even more, but first 3 months are required, so that you have a pretty good idea of, okay, I got to pay the franchisor X number of dollars, and I'm going to pay the franchisor blank dollars or X percent. But apart from that, what's it take, to lease a place, build it out, if possible, get a vehicle, get insurance, hire lawyers, hire accountants, get an initial packet of marketing materials for an opening marketing blitz, those kinds of things. They're all in, or should be in, that item 7.
Yes. Yeah. So we've got the 23 items. I like how you summarize those first 4 items, and then items 5, 6, and 7 is where you're getting to all the different fees. And like you said, the item 7 is that estimated initial investment that it basically details out all of the expenditures in the low end and the high end to launch this business. And does that typically represent a 3-month window? That item 7, the estimated initial investment?
Correct.
Okay, and I do like to share that the actual franchise fee, which is the one-time fee you pay upon the signing of the franchise agreement, is included in that item 7 table.
It's in there. Yes.
Yes. Okay, great. So that's all inclusive. Okay, so walk us through after item 7. What are some of the other items?
So item 8 basically is an indication of whether or not you're going to be restricted as a franchisee to buy from to get the franchise up and running, or during the course of the franchise relationship from the franchisor affiliates, like related companies that provide various services such as marketing or computers or something proprietary to the system. And then and that's a very important disclosure, because it tells you not the percentage of tie-in you have, both initially and during the course of the franchise agreement, and whether or not you are going to be able to go out on your own and source products and supplies and get approval. So that's all in that one. And then item number 8 are the obligations of the franchisee. What are you required to do? Item 9, is laid out by chart. Item 10 is that if there's any financing that the franchisor and affiliate makes available for you. And then there's a long item 11 disclosure that has several things: franchisor assistance, advertising, the computer systems you required, the training with detail on who the trainers are and their experience. So there's a lot of meat in that one.
Yes.
Item 12 is territory, very, very important. It's extremely important that you understand what you're getting, what carve out is yours. Is it exclusive? Is it not exclusive? And one of the key things that I always look into and advise franchise prospects to do is read the reservation of rights in the clause in the FDD and in the franchise, because almost every franchise agreement written in the last 10 years has carve-outs for the franchisor to have certain business activities going on in your territory. And so you have to be very, very careful about it. It typically is under another brand, or it's a carve out, what we call captive venues, like sports arenas and airports, or internet sales, or national sales that are restricted to the franchisor. But it's important to really know what you're getting and what you're not getting.
Absolutely. No, I'm so glad you brought that. One of those, I guess, dangers, right? The important tip, if you want to call it that, right?
And then disclosure about trademarks. And trademarks are the hallmark of a franchise. And being a trademark lawyer also, I look at that pretty carefully, because you can franchise if you don't have a federally registered trademark. But you have to have a bona fide belief that you're going to get it. In other words, you have to have done your due diligence, done a trademark search, make sure that there's nobody else with a name or a logo that's going to be, and this is a buzzword, confusingly similar to yours to infringe upon it. And I look at that pretty carefully, because particularly with QSR, there's going to be a big expense, and you want to make sure that these marks are locked down. And one of the things that I look at is, what's taken so long? Now, the trademark office is notoriously slow, especially now since COVID and end of COVID, in getting getting applications reviewed and passed. But if something's going on 2-3 years after it's being filed, that's kind of a red flag. Go take a look and go on the Patent and Trademark Office's website and see if there's some objection or something going on. It should be no more than 2 years. And if it's anything longer than that, you need to dig in.
Makes sense.
Okay. So that's trademarks. Patents, copyrights, and proprietary information. Those are usually, not a lot of franchises that I've seen or reviewed that have a patent, but everybody believes that their manuals or training manuals and operational manuals are proprietary. So they indicate that in that section there. Then item 15 is a short disclosure. Are you required as the franchisee to operate it? Can you have a manager? Must the manager have equity, skin in the game, or can you just hire a manager? And if you hire a manager, does the manager have to be trained? So that's the information you typically find in there. And
Can
then
I touch on something there real quick, Jim?
Sure.
Something that I have heard certain franchisors do is, if you are not going to be actively operating the business and you are going to be hiring a general manager, to operate the day-to-day. I have had some franchisors tell me we require that general manager has at least 10% equity in the business. Have you seen much of that?
I have, and that's kind of a red flag. I sort of understand it, but 10% of equity is
Yeah.
expensive,
Mhm.
and that's something that if you feel you're in the position to negotiate and push back, uh, I would try to push back on that and bring it down. And then, of course, if that manager leaves, that requires you to go to a very good attorney that can, make that business divorce comfortable so you can get that 10% back.
Right.
So there are those issues with it too.
Mhm.
It's I don't see it as much as I see liquidated damages clauses, which are more prevalent. But there are franchisors, and I'm not trying to knock them on this. If there's an investment and the franchisors want to protect their brand and want to be able to prove this manager, that's all well and good. And they may feel that based upon their knowledge and experience of their system, you got to incentivize, the manager who's really boots on the ground with equity.
Makes sense. That makes sense. Thank you for clarifying that.
Sure. And then going on, there's restrictions on what the franchisee may sell. This is usually a pretty short disclosure also. And it talks in terms of, what product you can and can't, or services you can and cannot basically sell. And again, talks a bit about, you got to use our stuff rather than somebody else's stuff unless you get our approval for it.
Yes.
And then there's some legalese stuff. Item 17 is a long disclosure on renewals, termination, transfer, and if we get into a dispute, is it going to be mediation, litigation, arbitration, where, under whose laws? All that is in item number 17. 18 is straightforward. Are there any public figures that are, basically touting, and then you'd have to disclose that. 19 is the famous
I know.
performance
Don't go
representation.
too deep there because I'm going to circle back around to some of these
Okay.
fees and money.
Sure, we'll talk about that for sure. Item 20 is one that I think a lot of people getting into franchises skirt through, and particularly with this, there's not much information there if it's a brand new franchisor.
Sure.
But if it's somewhat seasoned franchisor, these are really, really important charts. It's all in chart form. And I think people don't pay as much attention. I can tell you that when we go to our franchise lawyer meetings, the regulators show up, and if they hone in on that as one of their, item 20, those charts is one of their indicia of how well a franchisor is doing and the health of the franchise system. So if they see these things and work with them more than any individuals in America. So if they're telling us that, it behooves us to pay real attention to it. And you can really, if you know what you're looking for, get a real good flavor for the financial health and wherewithal by who's in the franchise system, who's leaving, who's been terminated, who's been non-renewed, all those kind of bits of information are in those charts.
Now the item 20 that has, all of that data, those charts, it's a 3-year snapshot, right? A 3-year snapshot of the growth or the attrition that is happening within the franchise system.
Right.
And do you think there should be concern if you're seeing a significant amount of attrition, or is there sometimes good reason for that?
You hit the nail on the head. Absolutely. I had a war story here, short one. I had a young man whose family was in franchising fast food, and he decided to get into another franchise totally unrelated to fast food. And that involved getting into a very expensive long-term lease. And unfortunately, things did not work out, and he had a tremendous liability under the lease and to the franchisor for many years of royalties and ad fees and the like. And when I looked at that FDD, I asked him if he had an attorney representing him going in, and he did not, because he felt that he had previously been in franchising. And I looked at the attrition, and this is a household name franchise, international, and 25% of their franchisees had bolted within the 3-year look back period. And that to me was a huge red flag, just to your point.
Yes. Good. Thank you for that. Agreed. So what happens with 21 and 22? Item 21 and 22.
So 21 is financial statements. In non-registration states, and if I need to explain that, I'm happy to do that in a moment. In non-registration states, you get a year pass without having audited statements, but then you must come into compliance and have audited financial statements on an annual basis. And these are typically done on a 12/31, and they need to be in place by 4/30 of the following year. Otherwise, your franchise documents go stale, and a franchisor can't sell. In franchise registration states, sometimes they're required by those states upfront initially with no phase-in period. But that's just something that you need, attorney to look into. But that's the financial statements, and the contracts. The law requires, that's item 22, that every contract that you're required to get into the business and sometimes out of the business needs to be in that document. And that's what makes the document so bulky, because not only do you have to have the franchise agreement, but every other document that is required to be signed or that could be signed, even ones that are looking for exiting the system down the line. The prototype of that document would also have to be included in the FDD.
Yes.
And then the receipt, item 23 is just the receipts. That's sometimes misunderstood by prospects. They don't want to sign something. Well, I haven't read it yet. And you're telling me, so, well, understand, it's just signing that you saw the document and you've got it, and that starts your cooling off period under law of 14 calendar days, where you can't, sign, and the franchisor can't have you sign, and you can't deliver any money, but you have to sign the receipt, right, or nothing gets done.
Right. You can't move forward unless they have that acknowledgement of receipt and that showing that they've disclosed you with the FDD, the franchise. You brought up something about that, the FDD can look pretty bulky, and that bulkiness can also make you think, oh, wow, this is a lot to read. This is overwhelming. I just to help any prospective franchisees that is looking at this FDD, I like to say the first half of the franchise disclosure document is really just providing you with information on those 23 items and what's supposed to be non-legal jargon. And then the actual franchise agreement, which is ultimately what they would be signing, is an exhibit within the FDD. So it's almost like you got the data twice. One's more for, let's call it non-legal jargon, and the other one's the actual contractual agreement that you would be signing, which is an exhibit, basically taking those 23 items and putting in the contractual format. Is that a pretty good summary?
It's a very, very good summary, and there's a lot of duplication, obviously, because of that. When I do reviews representing franchisees, I always read the FDD first, because it gives, real background information. And there's so many ways to skin a cat. So the franchise agreements are, that I have written or that I see, have a lot of commonality to them. So what I tell clients is, this is what we'll focus on, but the idea is once we understand all the detail in the FDD, it's the franchise agreement that's the binding document that you're going to be signing, and hopefully you'll put it away in a drawer and nothing will happen until you renew 8 or 9 or 10 years later. So that's really the document that controls, but you really are doing a disservice if you don't spend equal amount of time on the FDD.
And speaking of exhibits, another very important exhibit is the list of the franchisees.
Thank you. Thank you for mentioning that. I've always been surprised at how open franchisees are to prospects, total strangers, calling them and saying, can you tell me about, your experience? Are you happy? How you doing? I mean, and so many of them just take a deep dive into it and share quite a bit, which is wonderful. So you have to avail yourself of that opportunity, because it's required of the franchisor not only to give the ones that are active, but equally, if you can find the ones that have left the system, those names, addresses, and telephone numbers and email addresses are also required by federal law. Check them out too if you can get a hold of them, and you'll get that perspective too. Do your due diligence.
Do your due diligence. Validate, validate, validate.
Right. Exactly.
So let's get to more numbers, because that's always what we want to fully understand when we are moving into business ownership.
Sure.
So I want to circle back around to the fees. Remember items 5, 6, and 7. We talked about item 7, that estimated initial investment. But now I want to talk about royalties. And that's how the franchisor makes their money, is there's a royalty. What do you most commonly see? What's the common formula you see for royalty?
Most commonly, we see percentages. And what I tell clients is I typically see a low of 3% and a high of 10%, with the norm being 5, 6, and 7, 5, 6, 7, 8%. There are some franchise systems that do flat fees. Some are required to do them. Some of the medical related franchises for basically fee splitting and regulations for Medicare, Medicaid, and these things, you oftentimes see in those franchise agreements flat fees and not percentages, because you shouldn't be splitting. Some regulations prohibit splitting fees of a non-professional franchisee with a professional like a doctor, that type of thing. But oftentimes there's a mix, and a lot of them, some I've written and many I've reviewed, say 3%, but not less than 2,500. So in other words, the franchisor is covering him or herself, and on the other hand, the franchisee knows what the responsibility is up front. So, and oftentimes there's a phase in too, Pam, where the royalties don't hit exactly in month 1. So that's something a franchisee, particularly with a young franchisor, might want to negotiate and say, hey, I've just laid out all this money for the car and for the rent and the equipment package and the opening marketing. So can we cut me some slack on the royalties and for X number of months? So a lot of franchisors, if you ask, are willing to do it.
That's nice. Yeah, just it's not changing the percentage or the minimum royalty. It's just really deferring it.
Right.
Yeah.
We rarely see franchisors, and putting my franchisor hat on for the moment, franchisor lawyer hat on for the moment, I would tell a franchisor to negotiate almost everything before I had he or she negotiate the percentages of the royalties. That's their stock and trade. Put another way, statistics bear out that the initial franchise fee, by the time brokers are paid, if there's brokers, cost of sale, advertising, yada yada, you don't make a ton of money as a franchisor on the initial upfront fee. It's the royalty stream. And it also candidly shows a weakness on the franchisor's part if they're willing to negotiate those percentages. Now, the initial franchise fee, wide open. Go for it if you can, particularly with a young group, or if you're buying multiple units. Now, you're going to go to McDonald's buying one unit. I mean, I don't think you're going to negotiate too much. But yeah, that's one end of the spectrum. The other end of the spectrum, of course, is a new franchisor wanting you as much as you want them because you're buying one or more, and they've got to get the sales going.
Yep, makes sense. Another important fee for any new franchisee when they're building out their pro forma are the marketing fees. Usually have that national and local requirement. Tell us what you commonly see there.
In terms of the advertising?
Yes, the marketing funds.
Sure. I typically see, and we've talked about it a little previously, some sort of marketing blitz upfront. And in the dozens of franchisees that I've done reviews and assisted, I rarely see any pushback from that. They understand the need, to get in there and blitz the market, build the brand in their particular territory, work with professionals that have expertise that are recommended to them by the franchisor. So that's something that I don't see too much pushback from, and an understanding. The ongoing royalty advertising and marketing comes in various different forms. There's always going to be some sort of a marketing fee. The range typically is 1% to 4%. But on top of that, and another thing to be careful about is there can be co-ops, regional co-ops. Oftentimes they're not started immediately, but during the course, as you get more franchisees in a particular area, they band together, and that's an extra 1% or 2%. Some of the franchisors will give a credit to the money that's spent on a co-op. So look for that when you're reviewing it, because instead of, or they'll put a cap on total advertising expense, regional, local, national to them of X percentage. So those are things that, might be able to be negotiated.
Okay, that's good to know. I want to circle back around because I know we're going to run out of time here, and we can hang out and do this all day, right? Franchise law is such an exciting topic. But with that being said, let's talk about the most talked about item in the franchise disclosure document, which is the item 19, which stands for financial performance representation. What do we commonly see there? And we also talk about, and I'm sorry, James, sort of a sub part to that is, would you please share what the franchise law is when it comes to the item 19, the financial performance representation, and why there are so many restrictions around that for a franchisor to be able to share with the prospective franchisee?
Sure. First of all, they're not required. They're optional. Again, it would be anecdotally, and don't hold me to it, but I've heard and I've seen at this point now 60 to 70% is probably a number that I'd feel comfortable throwing out of franchisors that have some form of FPR in their document. It's very important because there's a total and absolute prohibition on discussing numbers unless they're in the FPR, and you can't vary from the numbers verbally either. So if you're going to talk numbers as a franchisor with a franchisee, they have to be in there. There's the guidance overall is relatively general. The state regulators and the FTC are are not going to necessarily tell you the format it has to be, but what they do tell you, and they will monitor, is, are they accurate? Are they reasonable? Are they something that is based upon experience? And if there are projections in some portions of them, have you disclosed that in a footnote to make sure that you state that? So in other words, the whole FDD is truly what we lawyers call an anti-fraud device to protect people that are making big investments, lifetime decisions, so they get information and it's accurate, it's not misleading. And that's the overall arching thing. So that's the 50,000 look at. But when you get into the weeds and you dig down, what you really want to see is numbers that are historical, they're relevant. What do I mean by that? Well, if you're just getting company locations, which is franchisor numbers, at a minimum, they ought to be disclosed that there's no royalties being paid to themselves. So that's one thing for sure that ought to be disclosed. So whack off those advertising fees and royalties and then get down to that number. Most franchisors know that and footnote that. Obviously, if the franchisor has been around long enough, you want to see franchisee results. And typically, I tell my franchisor clients, I don't feel real comfortable unless a franchise unit has been in business 1 full year. Have I seen less than that in documents? Yeah, I've seen 6 months franchisee results. I've never seen anything less than that. But so typically as a guideline that I like, and I see that a lot where a franchisor's FPR will say, we have 50 franchisees, but only 20 of them been open the last year. So we only have numbers on the 20. And I think you got to accept that as being fair and reasonable because it's just too short a period of time. But actually what you get in terms of numbers can vary significantly. You can get only gross revenue. You can go get gross revenue, net profit. You can get gross revenue, gross profit before expenses. You can get franchisor only if that's what they're doing, franchisor and franchisee. They're normally not mixed. They're normally separated if you're going to get both in separate charts, but there aren't any hard and fast requirements, only what I had indicated. They have to be material and they have to be accurate and not misleading.
Right. So we know that the franchisor has a fence put around them in regards to speaking to any type of financial performance representation or making any earnings claims, unless those data points are actually in that item 19. We were talking earlier about the validation step. What about franchisees? They don't have that same fence put around them when you have an opportunity to speak with franchisees. And are there any restrictions put on?
That's a great point. Franchisees can give you a whole bunch of different perspective. They can give you exactly what's going on now, because there's always a look back. And very often, depending on the time of year that you're making the investment, it could be as much as a year and a half old, these financial statements and these documents. So it's great to get the franchisees to, talk to you about, what's actually current and what's going on now. And they may say, well, that hasn't been my experience. My costs are higher. My labor costs went up. We're having supply chain issues. So that there's those issues. So they're going to give you a whole lot more if possible, if you can get them to talk. And
Sure.
as I said, I think most of them are pretty open. It's a blanket statement, I realize, but it certainly behooves a franchise candidate to make those calls.
And obviously, it's great to speak with franchisees in the system. And I always encourage anyone that is in that validation stage and speaking with franchise owners that they be sure to validate the business model, not the business owner. Because as we know, there's a big gap when it comes to operators of a franchise system. And that operator can create a performance gap. It's not necessarily the business model. It might be the operator.
I agree. And the other thing that I tell clients, I don't tell them always, for instance, I probably wouldn't get into this in a QSR, restaurant franchise, but others, because a lot of services are being franchised now and product, is this something where, I mean, it's hot now, but technology is going to change, or it's predictable that the public's appetite, quote unquote, will change. And it's a one pony type of situation. And where are you going to be as things evolve? It's really important to talk to the franchisor and feel comfortable if it's the kind of franchise that's based on a product or a service, that they have a vision to the future.
Yeah. And actually, that's a great lead in. And I know you didn't mean to do that, but that's a great lead in when you said vision into the future. I always tell people you want to start with the end in mind. And that's a quote, it's been out there forever. What are some common exit strategies?
Sure. One of the things I've been telling franchisee clients is if you want to sell rather than renew, most franchise agreements have a right of first refusal where the franchisor can buy it back. In my experience, I've rarely, if ever, seen a franchisor do that. I'm not saying it doesn't happen.
Sure.
I'm just not aware of it. So presume that the franchisor is probably not going to want to buy your business back. So if let's say it's a 10-year term, if you know in your 8th year that it's been a good run or hadn't been a good run for that matter, but you're not renewing and you really want to cash out and so on, make sure you got a good business broker, put that franchise up for sale and get it evaluated, get a fair evaluation and market it. Because if it gets to the point where the franchisor is buying your assets, the formula that's in most franchise agreements is very disadvantageous to a franchisee. Doesn't normally give any consideration to goodwill, what you've built up. It's usually just depreciated value of fixed assets. So, if you're leaving, make it on your terms. Presume the franchisor, you have to go through the hoops, but presume the franchisor is not going to want to buy it and plan early. Again, if you're renewing, you want to know what's been changed. And odds are you probably have a pretty good idea because you've been in the system. But there may be some negotiations to be had at that level too, in particular, rewarding your loyalty and continuing loyalty. There are some franchises that I've actually written a few of these agreements representing franchisor clients where there's a formula, a buyback formula. I was this past week reviewing one for a prospective franchisee, and it looked very generous. It was based upon a multiple of EBITDA that was pretty reasonable. But if anything like that, by all means, get legal and accounting help on that, because some franchise or documents say, hey, it's great, but in the 3rd or 5th year, we're going to want to exit as a franchisee. And that typically is because the franchisor may have an idea of either an acquisition down the line or, more importantly, going public. And they feel that they'd be more advantageous as a system with company-owned stores rather than franchise locations. So they want to buy them all back. And that does happen.
Yeah. I definitely know what you're saying. Great insight there. Well, in wrapping up, you've obviously shown your value and the value of having a franchise attorney work with you before signing that franchise agreement. I know that you have definitely worked with a lot of my clients, and I appreciate that. What would you say if someone's going, well, you know what, if I can't negotiate a lot, what's the value of retaining a franchise attorney?
Well, I know this is self-serving, of course.
Self-promote. Go ahead.
Yeah, but I would say take a look at the amount of investment you're making, the amount of money you're going to be paying this franchisor. Look at those numbers we talked about, and then Jim Ullman's legal fees may not be too terribly bad in relationship to the long-term investment, and maybe you'll get a kernel of knowledge that open up your eyes, or help you make a better decision. And I want to go on record as saying I'm not here to be a deal killer. That's not my experience. You can't be in the franchise world without being entrepreneurial yourself. And in fact, you made reference to my starting out as an in-house counsel many years ago for a company that went franchise. And you know what my boss, the president's motto was of the company?
What?
We never say no. So I learned to try to be flexible way back when.
Right. Adaptability will get you far.
Right, exactly.
No doubt. Well, thank you for that. And I do want to share with our listeners that franchise law is specialized. So don't go get Uncle Bob up the street who practices a different type of law. Franchise law is specialized. Very important. Well, James, thank you so much, or Jim, I'm accustomed to calling you James. Thank you so much for your wealth of knowledge and being on the show. It's been great having you as a guest.
Well, thanks so much for having me. I've enjoyed it very much.
Wonderful.
Need help finding a franchise? Don't go direct. Always call Franchise City Brokers to help find the best franchise for you.